The purpose of this training is to provide information regarding the Office for Dispute Resolution, its function, and activities. What is the Office for Dispute Resolution, commonly known as ODR? The IDA requires that each state have due process and mediation available to parents and local education agencies to resolve special education disputes. The Commonwealth of Pennsylvania meets this federal requirement through a contract with ODR. Although funded by the Department of Education, or PDE, ODR is separate and distinct from PDE. ODR administers both the due process and mediation systems in Pennsylvania. The ODR Stakeholder Council consists of a broad group of stakeholders from the special education community. When the council was first seated, ODR asked that stakeholder groups submit names of candidates for the Stakeholder Council. Now that the council has been operational for 4 years, the council itself, not ODR, determines its membership. The Stakeholder Council provides functional input to the director of ODR on the services of ODR. Most importantly, council members have interviewed hearing officer candidates when a position became available and recommended candidates for hire. The council will continue to provide this function as needed. As described in the previous slide, a due process hearing is mandated. Mediation is also mandated but voluntary, meaning both parties have to be willing to use mediation. But ODR also offers several other early and local dispute resolution options that can be used instead of or in addition to due process and mediation. They are the Special Education Consult Line, Parent and Family Engagement Project, Iep Facilitation, Resolution Meeting Facilitation, Creating Agreement Training, and the Hearing Officer Settlement Conference. This is a great visual representation of the dispute resolution continuum. Mediation is big and bold in the center because although it's a mandated service, it's also a voluntary service. To the left of mediation are the more informal or interest-based early dispute resolution options, and to the right of mediation are the more formal or rights-based dispute resolution options. Pennsylvania is proud to be one of 4 states considered an exemplar state in special education dispute resolution by the Center for Appropriate Dispute Resolution in Special Education, or CADRE, with approval by OSEP. ODR is very honored to be a forerunner in the area of special education dispute resolution, chosen because of the long history of outstanding programs made available to constituents. The Special Education Consult Line is a toll-free information helpline for parents and advocates who have questions or concerns about special education for school-aged children. Although developed by PDE, it later became a service of ODR in the year 2000. The highly trained and knowledgeable specialists provide information regarding the state complaint process, and they answer questions regarding the law, parents' rights, and procedural safeguards. The specialists are not advocates and do not give advice. Rather, they provide information and options for parents. The specialists can refer callers to a vast library of resources that are available to further assist parents and advocates. A component of the Special Education Consult Line is the Call Resolution Process, or CRP. We'll talk about that shortly. Consult Line staff are not advocates. They don't provide information based on their personal opinion, but rather on what the regulations and policy dictate. There are many alternatives to filing for due process or filing a state complaint. The specialists provide the caller with information about these alternatives. Have they addressed concerns with school administrators? Have they called an IEP meeting to try to resolve the issue? What about mediation or Iep facilitation? It's true that the specialist will explain due process or the state complaint, if relevant, because that is a right that the parent has. However, specialists also explain other options to try first. Because specialists are not advocates, they can't advise a parent what to do. So in the end, the parent may end up filing for due process, but it's the specialist's duty to ensure the parent is informed and knowledgeable about all the other options they have as well. Special Education Consult Line's phone number is located at the top on the very first page of the procedural safeguards notice. There are 3 specialists who handle the many calls that come into Consult Line. These specialists are educated, experienced, and qualified. They participate in many staff development and training opportunities to ensure they are always on top of the most current regulations, best practices, and trends. So how does a caller access Consult Line? Callers call the toll-free number seen here on this slide, and they leave a message. The outgoing message instructs the callers to leave their name, phone number, hours when it is most likely they can be reached, and a brief message about the nature of their call. Specialists are on duty from 8 a.m. through 4 p.m. Monday through Friday to accommodate callers. The calls are returned in the order in which they are received, and the specialist will make several efforts to reach the caller. An interpreter service is used when specialists are assisting non-English speaking callers. Here are some examples of some of the types of calls that come into Consult Line. Callers may have questions about compliance issues, or sometimes they need clarification based on something they've been told or something that they've heard. Sometimes it's just a plain disagreement between parent and LEA. Specialists can also field calls about Section 504 service agreements. Sometimes when talking with a parent, the specialist hears something that could be a compliance-related issue. And at times, the appropriate person at the LEA has not been contacted by the parent. With the parent's permission, a specialist might offer to send a courtesy email to the Director of Special Education at the LEA, notifying the administrator of the parent's stated concern, along with the parent's proposed resolution. Copied on this email are the Bureau of Special Education Regional Compliance Advisor and the Division Chief of the Bureau of Special Education. The specialist analyzes the conversation to determine if CRP could be an option. However, before offering CRP to the parent, the specialist covers all bases by providing information about state and federal requirements that address the issue. They discuss different options for addressing the issue locally. They explain the state complaint process and determine whether or not the issue meets the criteria to offer the CRP. But once the email has been sent to the LEA, the specialist's role is complete. It is then in the hands of the LEA to determine if a course of action is warranted. The BSE advisor will follow up with the LEA, and the parent has been advised that the LEA and or the BSE advisor might be contacting them as well. Here are some examples of the issues that could possibly be addressed through the use of the CRP. Non-implementation of the IEP is one. If your child is out of school, or if a behavior plan is not being followed. Again, not an exhaustive list, but some good examples. Consult Line provides support and information to parents whose children are transitioning from the early intervention program into the school age program of beginning with kindergarten. For issues concerning early intervention, evaluation, identification, or the IEP, IFSP implementation, Consult Line specialists will refer the caller to the Office of Childhood Development and Early Learning, or OCDEL. So let's take a look at family engagement services. Well, recognizing that due process is an important procedural safeguard for parents, the project manager will share information on alternative ways to resolve disputes, which are less contentious and more collaborative. One of those services that can be used early on is IEP or IFSP facilitation. Although not intended to be used for every IEP meeting, facilitation is available for those meetings when both parties agree that the presence of a neutral person might help them discuss issues that could be roadblocks to completing an agreed upon IEP. IEP facilitation is typically used when communication between the parent and the LEA has been hampered or stalled. The facilitator can help create an atmosphere for fairness and the successful drafting of an IEP. There is no cost to either the parent or the LEA to use facilitation for students with disabilities. And facilitation is also voluntary. So both the parent and the LEA must agree to the use of a facilitator. The law says that the LEA is responsible to schedule and hold the IEP meeting with the parent. IEP facilitation does not alter this requirement. The LEA sets the date for the meeting, invites the parent, and leads the IEP meeting. ODR only sends a facilitator after the LEA has set the date, time, and place for the meeting, and after both sides have agreed to the use of a facilitator. The facilitator is a guest of the IEP team, not a member of the IEP team. So new to the Pennsylvania facilitation model is the prep phase. So during the prep phase, the facilitator may attempt to contact the parent and school IEP team representative. They may discuss the purpose of facilitation, answer some questions about the process, and their role as the facilitator. This provides an opportunity for the facilitator to understand the concerns or issues that may be relevant to the meeting and the reason the request for the service was made. As stated in the previous slide, the facilitator is not a member of the IEP team. The IEP team remains the decision makers. The facilitator's role is to help communication and to help the sides address any disagreements or conflict that might be keeping the team from developing an appropriate IEP. Although many facilitators have strong special education expertise, their role is not to offer technical assistance or input regarding the content of the IEP. If the team is moving forward towards the development of the IEP, the facilitator will sit in silence. A good way to think of a facilitator is like a referee. If the game's going well, there is not much need for interference. At other times, the referee's responsibility is to get more involved to ensure fair play and to keep the game moving. There are several benefits in considering the use of IEP facilitation. Facilitation can help maintain or improve relationships among the IEP team members and families. It allows the parties to address conflicts right away. Because the facilitator is trained to ask open-ended questions, facilitation helps team members look at all avenues, including new options. Facilitation is more cost-effective and less stressful than going through due process. and the facilitator helps to encourage participation of all parties at the IEP meeting. Now we're going to take a look at mediation. Mediation is voluntary for disputes pertaining to preschool and school-age children. Both the parent and the school must be willing to participate, or the mediation session will not occur. If either party declines mediation, no one, including ODR, PDE, or the opposing side, can force the other to participate. In some instances, one of the parties may believe that a fact finder is needed to break the impasse, not a mediator. In that case, they will likely decline to agree to participate in mediation. Regardless of the reasons, however, ODR respects the decision-making of both parents and educators to participate or not in mediation, while of course encouraging consideration of this highly successful conflict resolution service. The spirit of mediation is one of collaboration and respect. For mediation to be successful, it is important that everyone comes ready and willing to discuss the issues that brought them to the mediation table. If not, mediation may not be successful. If it is successful, however, and an agreement is reached, a written agreement is binding in a court of law. It's also important to remember that using mediation in no way takes away the right to due process for either the parent or the LEA. Many times, mediation is requested at the same time as due process. And because mediation can be scheduled in much less time, if parties go to mediation and reach agreement, the due process request can then be withdrawn. Mediation is less stressful, less expensive, and less time-consuming than going to due process. In many cases, mediation is a good alternative to try before going to due process. Once both sides have indicated their willingness to participate in mediation, ODR handles the details of coordinating the date and time, obtaining the list of participants from each side, and scheduling the mediator. For IDA-related mediations, there is no cost to either side for the mediation. In gifted-related issues, if mediation is agreed to, the LEA will cover the cost of the mediator. Here are some examples of the types of issues that can be brought to mediation. You can see issues of that free appropriate public education, educational placement, least restrictive environment issues, evaluations, accommodations. Again, not exhaustive, but here are some good examples. So who can attend the mediation session? While the regulations do not state the number of participants who attend mediation on either side, ODR recommends 3 participants to each side, although the parties may agree to something different. For the parents, they can bring anyone who has knowledge of their child and his or her disability. It might include an advocate, a therapist, even a family member or friend who understands the issues and can support the parent. The local education agency will select their participants, one of which must have the authority to commit resources, meaning this person can make decisions for the LEA. At the mediation, the LEA will be asked to sign a form that indicates they have this authority. In Pennsylvania, parents have the option of bringing an attorney to the mediation session. LEAs may only bring an attorney if the parent has chosen to bring an attorney. For mediations surrounding children in the infant-toddler group, or that birth through 3 years of age group, there are a few differences in the mediation process. For these mediations, the process is not voluntary for the infant-toddler early intervention program. If a parent requests mediation, the infant-toddler program must participate. And for this age group, the mediation must be held within 10 days of receiving the request. If mediation is successful, the Office of Childhood Development and Early Learning, or OCDEL, receives a copy of the signed agreement for follow-up. Although children in the 3 to 5 year age range are also served by OCDEL, there are no established timelines for mediation for this age group. So what can you expect at mediation? First is the opening statement. Each side gets uninterrupted time to tell their story to the mediator, to explain to the mediator what brought them to mediation. After both sides have given their opening statement and the mediator has asked any clarifying questions needed to understand the situation, there will be a joint session. Whereas the opening statement is between the mediator and the individual side, the joint session is where dialogue between the two sides occurs. At the start of the mediation, there might be little communication between the parent and the LEA. As the joint session continues, the mediator helps the parties begin conversations to address the issues. At some point during the mediation, the mediator might ask for a private meeting called a caucus with each side. This might be needed to gather an understanding of any roadblocks preventing agreement. It's also possible that either or both participant groups will ask for a private caucus during mediation. After caucus, the joint session resumes. It's important to understand that the unique needs of each mediation determine when, if, and how often a caucus is used. The goal of mediation is to reach agreement, and the mediator will work diligently with the parties, assisting them in reaching this goal. If agreement is reached, it will be put in writing, with both sides given a copy to take with them. The IDA states that mediators must be impartial, trained in effective mediation techniques, and knowledgeable in laws and regulations relating to the provision of special education and related services. The independent contractors for ODR come from a diverse field of experience and expertise that includes mediators, attorneys, consultants, former educators, therapists, and professors of special education from colleges and universities. Mediator biographies can be found on ODR's website. Now let's take a look at the more formal procedure of due process. Due process hearings are considered the more formal dispute resolution option, and that is because they mimic an actual court trial. So there are two opposing sides, the parent and the LEA. They are allowed to make opening and closing statements. They're allowed to call witnesses and cross-examine witnesses. They're allowed to present evidence. All of this is done in front of an individual called the hearing officer, who is acting like a judge in the proceedings. Most of the due process requests that come through ODR are initiated by parents. However, due process can be requested by either the parent or the LEA. Due process is available for families of children who are or are thought to be a child with a disability. It's also available for gifted students and for protected handicapped students. Due process is available for disputes regarding the identification, evaluation, educational placement, or provision of a free, appropriate public education. IDA requires that hearing officers have extensive knowledge in special education law and have the knowledge to legally conduct a hearing and write a decision. ODR's hearing officers are all attorneys. The national trend is for hearing officers to be licensed attorneys. ODR employs 5 full-time hearing officers. In addition, ODR contracts with a hearing officer who has oversight of overflow, conflict, and gifted cases. In an attempt to give parties every opportunity to reach agreement before the need for a due process hearing, IDA requires that when a parent requests due process, the LEA must hold a resolution meeting with the parent within 15 days of receiving that request. The parent and the LEA may choose to waive the meeting, which would be done in writing, or they may agree to use mediation instead of the resolution meeting. ODR tracks this resolution meeting data and reports the information gathered to the Bureau of Special Education, or in the case of early intervention cases, it gets reported to OCTEL. If a case is fully adjudicated, this means that both parties have presented their respective cases and the hearing officer has rendered a written decision. A hearing officer writes his or her decision based on the evidence, on fact-finding, on the credibility of witnesses, and on conclusions of law determined through the hearing session or sessions. Some of the most common issues addressed through due process include compensatory education and IEP dispute, educational placement, and evaluation, including independent educational evaluation and evaluation report issues. Sometimes the director of ODR will get calls from a parent or LEA asking if a hearing officer's decision is correct. Hearing officers have complete authority over their cases and the decisions rendered. ODR provides the administrative support for the hearing officers, such as case managers, equipment, trainings, but the hearing officers and the mediators are free from interference or influence on any matters affecting the outcome of individual mediations and due process hearings. If there is a concern that a decision is not being implemented, the party should direct that concern to the Bureau of Special Education or direct it to OCTEL in the case of early intervention cases. Now let's take a look at resolution meeting facilitation. Resolution meeting facilitation is available for any parent-initiated due process request that involves a child with a disability. It is voluntary and free. There's no cost to the parent or the school. After the LEA and parents schedule the meeting and agree to use a facilitator, ODR schedules the facilitator. If the resolution meeting facilitation results in agreement and all of the issues are resolved, the parent can ask the hearing officer to withdraw the due process request. The facilitator helps the parties focus on the child, helps keep the lines of communication open, and clarifies points of agreement and disagreement. The facilitator is impartial and does not make decisions for the group. If requested by the parties, the facilitator may help the parties write up their agreement. So why use resolution meeting facilitation? So some of the benefits include it helps to build and improve relationships. Resolution meeting facilitation provides the opportunities for parties to resolve conflicts and reach agreement that could prevent the need for due process. Using resolution meeting facilitation encourages parents and the school professionals to identify new options for the child. And resolution meeting facilitation, like other early dispute resolution options, is less stressful than going to a due process hearing. Next, we'll take a look at the Hearing Officer Settlement Conference. A Hearing Officer Settlement Conference is a service where parties who are close to a resolution but have identified sticking points or roadblocks can work with a settlement hearing officer to see if the sticking points or roadblocks can be overcome so that the parties can avoid a hearing and can move to finalizing a resolution. Knowing the importance of attempting to resolve disagreements as early as possible, the Hearing Officer Settlement Conference keeps the focus on the student's education instead of litigation. The due process hearing remains scheduled unless the parties tell the due process hearing officer that the case has been settled and a hearing is no longer needed. Here's a good side-by-side visual of the similarities and differences between due process and mediation. You can see the biggest ones are in bold, whereas due process is considered a little bit more adversarial. Mediation is considered more collaborative. Due process is mandatory. Mediation is voluntary. So this is just a good side-by-side that compares the two services. Creating agreement training. Although ODR has been providing conflict resolution training across Pennsylvania since 2002, it was in 2008 that ODR joined the national effort to build capacity for early dispute resolution through creating agreement. Since 2008, Pennsylvania has been the lead state in the nation for delivering this training. Now ODR is investigating ways to expand the outreach of creating agreement, such as online trainings and other cost-effective methods of delivery. The one-day training uses interactive activities involving relevant special education scenarios to help parents and educational agencies enhance their communication and problem-solving skills. Training is available at no cost to LEAs and parent groups. For more information about creating agreement trainings, contact information can be found on ODR's website, which is listed here on this slide. The website, ODR's website, also contains additional resources for families and advocates. Some of the things that can be found on the website include ODR's annual report, which provides statistics on ODR's services, as well as information about the projects ODR is currently working on. Here are some other additional resources that can also be found on ODR's website. There are good parent guides out there for parents who have an active case and who need some assistance in preparing. There's also some informational videos and publications to assist parents as well. ODR is committed to early dispute resolution activities and continues to be proactive in seeking out and expanding options to help parents and local education agencies work together towards agreement. In addition, ODR is committed to investigating cost-effective technology options to increase public outreach and availability of services for all constituents across the state. New videos coming out on ConsultLine, why mediation, and an overview of services. Other videos are in the planning phase. New ways for ConsultLine to connect with parents is also coming. This quote by Nicholas Martin gives us something to consider regarding conflict and dispute resolution. The strength of a relationship is not to be measured in the frequency or magnitude of the difficulties encountered, but rather in the ability to resolve them. ODR continues to seek out and offer ways to help parents and schools work together for the benefit of the child. ODR encourages you to consider the options discussed in this training. If you want more information on the topics discussed or need information on how to access these activities, please visit our website at www.odr-pa.org. Thank you very much.